So, as it relates to legal theory generally, what we're describing is really what law can be defined as. What are the rules of this, thing, this concept that we call law, right? What is the nature of of the legal system, or the nature of legal concepts, right? And we're going to be looking at the two major fields of study, right? Or two major areas of study, which is generally the natural law school of thought and the positive law school of thought, right? So for the definition of law per se, can anybody just give me a definition of law? Even though we know in its entirety that law itself has no static definition, what is a good working definition of law that we have?
Sir, law is an enforceable body of rules that guides conduct or behavior in society from a legislative authority.
Lovely. From a legislative authority. Okay. So it's a enforceable body of rules, right? That allows a society to produce certain types of conducts, right? So it enforces, right, these sets are these guidelines that help society to conform in certain ways. Okay. So you also stated that it stems from a legislative body, right? That is a positive law construct, right? But we'll look at it. So that's generally a definition of law. Anybody else have any other different definitions of law? Any other different definitions that we have? No? All right. So I'm gonna assume that that is the only definition that we're getting. Okay, let me see. So in the chat, there's gonna say an enforceable body of rules, but you already said that. Okay, so an enforceable body of rules. So the concept of law itself, we know that it's multifaceted, right? And it has been interpreted by multiple different scholars and philosophers throughout the years, right? There are different systems of laws that we generally talk about. We speak about the justice and fairness of law. We speak about the legitimacy and authority of law, right? Throughout this entire syllabus, we have looked right at the dynamic and evolutionary characteristics of law, as well as its role in being an enforcement, and its role of being this guiding principle that sets social order and stability, as well as its enforceability, right? So law itself, as we stated before, which is a really good definition, right? An enforceable body of rules, right, that guide behavior within society, right, that usually, right, stems from some amount of a legislative pronouncement, right? So that's generally what law would be categorized as. All right. Not sure if there are any issues there, but everything should be fine. That's generally what law is said to be, right? So we're looking at the fact that it's a normative system, right, of different standards and conducts, right, that guides behavior within society. It is enforceable, right? So if there is a rule that is not enforceable, it could be what we call a moral or a societal rule, but it can't necessarily be a law if it is not enforceable, right? We have social order and stability that we gain from law specifically. So law can help with different types of regulatory mechanisms regulating conflicts, disputes, stuff like that. It ensures some amount of justice and fairness along with equity, right, as an important source of law, right? We know that it has some amount of legitimacy or authority, right? Whether or not it has divine authority, right, or sovereign authority, right? And it does evolve with social, political, and cultural developments, right? So as a society develops, the law may change to fit the society, right? As the society changes, the laws change, right? Or so it ought to be. Okay? So the nature of law specifically, right? When we speak about the nature of law, we're really looking at the normative system of law, the social institutions, and the enforceability of law, right? Law is a system of norms, rules, and principles that prescribe and regulate behavior within society itself, right? So we know that we'll establish a certain lines of conduct, right, that individual groups and institutions must abide by within the society, right? Law is also a social institution that reflects and shapes the morals, values, and beliefs of a society, right? It helps with the common good. It helps with a common sense of identity within its own jurisdiction. Persons who did Caribbean studies would have understood how law, right, or the legal field will act as a social institution, right? So it helps to organize and structuring other social institutions as well as maintaining order within a society. Its enforceability is also a key nature, right, in and of itself, right? So the characteristic of law is another defining characteristic of law would be its enforceability, right? It can be backed by the coercive power of the state, which means that violations of legal norms can result in sanctions and penalties imposed by governmental authorities, right? So that's another important nature of law itself, all right? Not if remember if there are any questions or concerns, all you have to do is raise your hand and we'll hear you out and see if we can answer your questions, right? So anything at all, it doesn't matter what it is, you can raise your hand and go ahead. All right. So the role of law in society, this is something that would have known already, right? So regulation and order, right? So the role there, right? It tends or it helps or it ought to regulate behavior and maintain social order. So law is used to maintain social order over individuals within a society, right? It helps to micromanage or to govern various aspects of human conduct, property rights, contracts, criminal behavior, civil disputes, etc. Right? So it's used as a form of civil control there, right? It helps to protect the rights and the rights of people, right? Of the people within its general jurisdiction. So when we reach public law, we'll talk about the Declaration of Delhi and the Declaration of Rights of Man and all of these different pronouncements that are imbued within international law that assists with delivering the rights, the general rights that we know of, right, such as the freedom of speech, freedom of assembly, freedom of religion, right, those type of things. These fundamental rights and freedoms, right, for citizens, right? So the law is there to also protect these rights and freedoms, right? So dispute resolution is also an important thing, right? So the law provides many different mechanisms and avenues for resolving any type of dispute, either by litigation through the court system, mediation, arbitration, negotiation, conciliation, all of these things that you look at in alternative dispute resolution, right? So it offers avenues for different individuals or groups to seek justice. All right. The promotion of justice itself is another role of law, right? So it seeks to promote justice and fairness, ensuring that all members of the society, right, are treated in an equitable way under the law. We're going to be speaking about the rule of law, specifically in public law, right? So that's one of the underpinning rules of law there, right? The rule of law in its entirety, right? And looking at different types of doctrines, like the ultra virus doctrines, whether it be procedural, right, or regular ultra virus, or we're talking about separation of powers. These things would have made sure that we have the promotion of justice within a society itself, right? So these are just four major rules of law itself. And we're speaking about law as a concept, right? Law as a field, law as a social institution, right? Or the legal system as a social institution. These are four general rules, right? So the functions of laws come from the rules as well, right? So we talk about the social control, the legal certainty and predictability, right? Conflict resolution and social change and progress. Law would actually have an important role to play within these specific functions. So I spoke about social control and conflict resolution, but legal certainty and predictability is also a key function of law itself, right? If we're going to be establishing these rules, right, to guide behavior and decision making within a society, right, then the law needs to be certain and the law needs to be somewhat predictable, and we can speak about that through the doctrine of stare decisis, which we'll look at in the sources of law. All right. Social change and progress. Law serves as a tool for social change and progress by enacting reforms, promoting equality, and addressing societal injustices. Right, so the legal system will evolve over time, reflecting shifting societal values, norms, and priorities. An example of this would be with the Bastardy Act, right, which has now been completely repealed. Right, so the Bastardy Act that existed within majority of the English-speaking Caribbean has now been somewhat repealed, separating the understanding of what is just a general societal rule versus what is law specifically, right? So if we can have a complete understanding, the Bastardy Act was a piece of legislation that led to the ostracization of females who actually engage in sexual relations before marriage, right? So that would fall under the Bastardy Act. It was completely frowned upon within the society, right? And it was deemed somewhat a legal issue as well, right? As the society changes, as different beliefs and values are instilled within the society, we can see now that the Bastardy Act itself has now fallen out of favor with the law. So it's no longer a legal issue, right? If a woman decides to have sexual relations before marriage, it's no longer a legal issue, right? Whether or not you want to see it as immoral or unjust within society, whatever it wants to be, it is not law. So it's no longer a piece of law. So the laws themselves can change within a society as the society changes. All right. So natural law specifically, can anybody just sum up natural law for me, please? What does natural law speak about? Where does it come from? What is it truly about? What's natural law about? All right. So let me read the chat. We're saying that law, it's law from from the divine being, the divine being, or a law from a divine being, emanates from a divine being. Law is from a divine. Okay, so it's generally the same thing.
Laws are shaped by religion.
So laws are shaped by religion, or laws that come from religion. So laws are said to come from gods or divine beings. All right. So, oh, somebody raise their hand. Go ahead.
In Calvin Eversley article, he took a statement from Lloyd where he said natural law basically provides a rational foundation for moral judgment.
All right. So that's his perspective there. All right. As you'll soon find out, I do not agree with natural law at all. But we're gonna discuss it, and then we're gonna have a discussion whether or not natural law or positive law makes sense. Right. But me specifically, I'm biggest defender of positive law. But we're gonna discuss natural law. Right. It has to be discussed. So we're looking at divine inspiration within the legal field specifically. Right. So looking here at Sharon Lloyd, right, she states that natural law theory posits a necessary connection between law and morality, arguing that legal obligations derive their authority from moral principles that are inherent in the nature of human beings and the universe, right? And that's her one of her quotes, right, from The Morality of Freedom, right? So that's one quote from a member of the School of Thought of Natural Law. Alright? Cicero also stated something. True law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands and averts from wrongdoing by its prohibitions. Right? So that's Cicero's understanding, or his what he had to say about natural law in his work on the laws. Right? So we're looking at some key principles coming out, right? They are claiming, right, that religious influence, right, brings about something that is called true law, right? So it brings about something like that. They're also claiming that religion, right, within law itself, or the religious principles behind, law itself, right, would have provided some amount of moral standing, right? These are the claims that they are making, right? So the source in and of itself, natural law, is derived from nature and reason, positing that certain rights and principles are inherent to human nature. These rights are believed to be universal and immutable, right, existing independently of human laws or governments. So we're speaking about the divine um, source of law in and of itself, right? So it brings about objective morality. Natural law theory suggests that there's an inherent moral order to the universe which can be discovered through reason, right? So it emphasizes the existence of fundamental moral principles that govern human conduct, such as the right to life, liberty, and property, and these different things that come from religious principles, right? So it argues objective morality. Right, we'll also have the universal applicability, right, that we can look at. So natural law proponents argue that its principles are applicable to all societies and legal systems, regardless of cultural or historical differences. They believe that certain rights and duties are inherent to human beings by virtue of their humanity. Right, so we're looking at these general principles. So universal applicability, we're looking at objective morality, and generally, these two main things would have been the pillars of natural law, along with the divine inspiration. All right? But the criticisms for natural law now, critics of natural law, which I am, critics of natural law theory argue that it can be subjective and open to interpretation as determining what contributes natural, right? Can be contentious. Additionally, they contend that natural law may not provide concrete guidance in resolving specific legal disputes, right? So we're generally looking at law that comes from some amount of, divine inspiration or divine being, right? And it's said to be completely objectively moral because the divine being said so, therefore it is right, right? And we're looking at, they're claiming that it is universally applicable because the divine being said so. Humans have an inherent right, right, to these different types of legal underpinnings, right, and it can be applicable throughout all societies, right? So these are some of the general principles within natural law theory that we speak about, right? So natural law examples, so this right to self-defense could be a good example of natural law, right? So looking at natural law theories that argue that the right of self-defense is inherent, right, to human nature. Right, so they posit that individuals have fundamental rights to protect themselves from harm, and the principle is often cited in legal systems around the world and recognized as a basis, as a basic human right. Right, we also have freedom of speech. So usually it's fundamental rights and freedoms that are great examples, right, for natural law. Right, so the right of freedom of speech, many proponents of natural law contend that freedom of speech is a natural right, essential for individual autonomy and pursuit of truth. Right? They argue that individuals have an inherent right to express their thoughts and opinions without censorship or interference from the government. This principle is enshrined in various international human rights instruments and constitutional provisions. So this comes from the law. Well, this comes from the Declaration of Rights of Man established after the French Revolution. Right? So many of these things come from Enlightenment principles for students of history. Right? So many of them really come from that. And so many of them really and truly come from there. Right, many of the natural laws come from Enlightenment principles, speaking about the rights, right, or the universal rights of all men to really, or all citizens, right, to really have these things, right, have these defenses, right, have these different fundamental freedoms, right, and usually persons start to argue that it comes from some amount of divine inspiration. All right. That's with natural law. For positive law, now we're looking at law that comes from the states, right? So we're looking at here John Austin, right? John Austin was really, he was really influenced by Jeremy Bentham, which was another positive, a member of the positive school of thought for law, right? And in his work, the province of jurisprudence determined, he states that the existence of law is one thing, its merit or demerit is another thing. Whether it be or be not is one inquiry, whether it be or be not comfortable to an assumed standard is a different inquiry. So what we're saying, is that law is law handed down. Law is coming through legislation. Law is something that exists, whether or not it gains merit is separate and apart from the existence of law. Whether or not it is seen as quote unquote just to a group of individuals is separate and apart from the existence of law. Natural lawyers would have supported the fact that, okay, if a law is unjust to a group of people, it is not law at all. But the major difference between natural law and positive law is that positive law states that whether or not it may be unjust, right? It ought not to be unjust, but if it is unjust, it is still law. They don't throw out the law like natural philosophers. There must be a legal process that takes place, right? So we look at the source of positive law. It derives itself from authority from human institutions such as legislation, judicial decisions, and custom. So we're looking at sovereignty, right, of law, right, the sovereign source of law. It is created and enforced by governmental authorities within the particular jurisdictions, right? So we're looking at that specifically. So it's quite different from natural law. We're looking at the legally valid norms specifically. So positive law focuses on the norms and rules that have been formally enacted and recognized by relevant legal authorities. Its legitimacy and validity are determined by compliance with established legal procedures, right? So unlike natural law, where some amount of divine inspiration or some amount of right reason has to be there for the law to be valid, for positive law, as long as it gone through the right procedures without procedural ultravirus, it is law, right? So these are key differences between them, right? We have the contingent on authority, whereas natural law itself is contingent upon natural rights for humans to live within these certain restrictions, right? Or from the pronouncement of a god specifically, right? Positive law relies on a contingent from the state, right? Or a body that promulgates it, right? Its content and application may vary from one jurisdiction to another and can change over time through legislative processes. So it is different from just the pronouncement of a divine being, right? But it is contingent on the authority of the state and the power of the state to enforce it. Alright? So that's another difference there between the two. The criticisms now for positive law. Critics of positive law argue that it can be arbitrary and unjust if it does not reflect fundamental moral principles or if it is used to oppress certain groups. Additionally, the positivist approach may overlook the importance of moral considerations in legal decision making. Right, so that's a criticism of positive law specifically. Alright? So examples of positive law would have been generally speed limits. Right? Speed limits have no divine inspiration behind of them, but it is codified into law because it has been passed through subsidiary and primary legislation. Therefore, it is prescribed to be law. We also have tax laws specifically, right? These are completely enacted and regulated by governments, right? There's no general divine inspiration behind of it. This is positive law, right? So we're looking at these two examples of positive law, really simple examples, and you guys should be able to find examples of natural laws within every single legal institution across the planet because they exist in every institution across the planet. It's really easy to find natural laws, right? And positive laws, right, are really easy to find, to be found in your own legislations, right? So you need to be able to speak about those different laws in your legislations, all right? That's really the overview of the natural and positive law, right? Are there any thoughts, any concerns? Any issues, any concerns, any questions? Go ahead. All right, okay, let me see something now. Somebody has a question. So positive law is subject to change, but not natural law. All right, so natural law itself, right, speaks to whether or not the law is for the benefit, right, or within the right reason, right, or within the right, right reason with the universe, right, for humans to exist in such a way, right? So natural law really states that it comes from some amount of divine inspiration, right? So we're saying that as long as the law is beneficial to the people, it will remain as law. But if it becomes oppressive, it will no longer remain as law. That's what natural law really is. That's a proponent of natural law. That's an underpinning of it, right? But with positive law now, positive law is subject to gain through legislative means, meaning that it doesn't matter whether or not the law is oppressive, it will not change unless legislation, right, is done. Natural law can change. So as we said, if natural law is seen to not be in standing with the people's morals, right, or not be benefiting the people, then it will fall out of favor, right? So that would be an example of the Bastille Act. Well, example with the Bastille Act there, right? So once it was completely morally corruptible, right, for females that have any type of sexual relations outside of marriage, right? So we had that, and it was legally enshrined. As society changes, it has fallen out of favor, so it's no longer illegal. Right? It's no longer a part of law. But if we were to look at generally the positive law now, right? Positive law will not change unless legislation changes, right? So we're looking at stuff like that. It's important to know that these are theories of law and not try to use it completely as concrete um things within law itself, right? So these are theories of law, how it comes about, and our different understanding and perspectives of how we look at law through a natural perspective or a positive perspective. All right, so that is really it.